You can't roll the dice and hope that it goes your way and then protest after the fact that the solicitation was clearly ambiguous and didn't really say what it said, right?
Welcome to the Optimize podcast, brought to you by VisibleThread. The Optimize podcast is your go-to source for expert insights on BD, capture, proposal management, and government contracting. Each series is hosted by an expert in the field, bringing their unique experience and strategies to every episode. We're excited to have Jeff Shapiro as our host for this series. Jeff is a partner at Cohn Resnick with over 20 years of experience in financial management, federal contract auditing, and compliance. In this series, Jeff and his guests will be diving into the challenges and trends shaping the GovCon space. If you enjoyed this episode, please subscribe on wherever you are listening. Now let's join Jeff on this episode.
Welcome, everyone. So glad you can join us for another episode of the Optimized podcast brought to you by VisibleThread. I'm your host, Jeff Shapiro. I'm very lucky to be joined by a fantastic lawyer I've been working with for a number of years now, Josh Duvall. Welcome to the podcast.
Thanks for having me, Jeff. Good to be here. And as always, enjoy our conversations. So it'll be nice to see this one recorded.
Exactly. Oh, it's going to be on the record now. So we're going to be careful.
On the record. There you are.
So let me give folks a little bio about yourself and please add on to it. Josh Duvall is a shareholder in the Washington, D.C. office of Maynard Nexon and is a member of the firm's Cybersecurity and Privacy Practice Group and the Government Solutions Practice Group. Unique thing about Josh is that he's a certified information systems security professional, a CISSP. Very interesting. Josh, I mean, you're into cyber, you're a lawyer. How did that happen?
Yeah, good question. So I worked for government contractors before going to law school, and I was a malware analyst and did some other IT stuff. And after law school, I sort of, got in the government contracting space as a lawyer, and thought it would be good, given my technical background, to take yet another exam, and that was the CISSP test, which folks say is like the gold standard. It's an inch deep and a mile wide, where you've got to know lots of different things about a lot of different domains. And so it's been a good opportunity to kind of, focus on an area of law that I really enjoy, which is government contracting, but also bring in my cybersecurity expertise, given the shifting landscape of federal regulations with respect to cybersecurity and making things safe. Because as one can imagine, defense contractors and even federal civilian agency contractors are a prime target for, cyber attacks, data breaches, business email compromises, nation state activity and the like.
Love it. Yeah. So Josh, today I thought I'd bring you on. I think we talk about a little potpourri of GovCon topics here.
I like that word. Good one.
See, now we have a great title for this.
Yep.
So I know you cover a lot of different areas on behalf of the firm. Let's start talking about one of the hot issues going on in the legal field is the organizational conflicts of interest. There's a proposed rule out there, and new administration. This is gonna be one of many key areas of focus. I would love to hear from you what you see going on in that area.
Yeah, this is an interesting area. I think we've been waiting for a change in that area for quite some time. And when any administration changes over, there's always sort of what comes to mind are the conflict of interest rules. So you've got, on the one hand, the organizational conflict of interest rules, which are currently under FAR subpart 9.5, but then you have all the other conflict interest rules that sort of relate to former government employees, and those questions have been sort of increasing as time goes on and as more folks are looking to come into the private sector by that are in the unfortunate position of being either RIFed or being asked to leave or whatever's going on in government at the moment. And so it's always timely to talk about these issues. OCI has historically been a creature of the case law, right? And so we've had, bias ground rules, impaired objectivity, unequal access to information. They usually come out in a GAO protest or sometimes in the Court of Federal Claims, and they're governed under subpart 9.5. And with this proposed rule, they not only sort of took it out of FAR subpart 9.5 into FAR part 3, creating a new subpart 3.12, but they've added a lot of clarity to what's going on in terms of definitions. They've added language on impaired objectivity regarding a determination of acceptable risk. And so they've sort of taken this regime that contractors have known about, that is subject to interpretations, and has tried to put it in a place where there's more certainty as to what is permissible and what is impermissible and what things mean. For example, they also, discuss firewalls, which is, another way that the government realizes that the contractors can mitigate these types of OCIs. So, I think all in all, it's a good opportunity to, again, with any proposed rule, not just this, OCI proposed rule, but it's an opportunity for contractors to engage with the rulemaking process. You've got an opportunity to respond, and that, at the end of the day, makes for a better regulatory regime when they're taking into consideration all of the folks that are going to be impacted by the rules. And so, folks might be saying, well, what does this matter to me? And you were asking me earlier about impaired objectivity OCIs. I mean, those are your classic, I think we remember from a couple years ago in the news, there was information about a consulting company that was doing work with one of the health agencies, and they were sort of on both sides of a national problem, advising certain private companies, but also advising in a different capacity government personnel and government for government purposes on the other, right? And so that kind of brought to light the need to maybe refine the FAR subpart 9.5. And so when you look at impaired objectivity from from your run-of-the-mill IT services contractor or what have you, it's the type of situation that kind of speaks to conflict of interest. It's where you've got interests that may impair your ability to give impartial advice. Well, if you're going to be selected for this contract over here, but part of this contract is to review the work of some other contract or program over here, and you are also working on that program or contract, like, how are you able to give the government the type of advice it needs when your interests are going to be impaired, because you also want to make sure that you're not jeopardizing your own concern. So the FAR addresses that, and interestingly, with respect to impaired objectivity OCIs in particular, the FAR Council has added language on determining an acceptable level of risk with respect to impaired objectivity OCIs, and the government will then consider a bunch of factors that may include whether the risks and the performance is manageable, right? What's the level of risk on this type of impaired objectivity? So as we move forward in the government contracting process, I think government contractors are going to have a lot more clarity, and there's going to be a level of flexibility that the government has with respect to determining an acceptable level of risk or mitigating or even waiving OCIs. So
the power determining whether or not that there's a conflict of interest, it lies in the contracting officers, right? And so, but it's up to contractors to have to prove it out. Are there specific tools that contractors can use? Does the rule lay something out?
Yeah, so there's, when we talk about OCIs, there's, you can avoid, neutralize, mitigate, waive, right? And so a lot of these OCIs come up in the sometimes they're on the front end where the government says this company X isn't allowed to compete, right? We've determined there's an OCI. A lot of the times they come in on the back end where you get a notice of unsuccessful offeror, and a lot of these contractors have knowledge of not only their procuring agency and customer, but also what other programs they're working on. And so you may have a situation where an unsuccessful offeror is thinking, well, wait a second, I know that company X that just won this contract is also doing this thing over here. How is that not an OCI? So that may be part of the initial protest allegation, notwithstanding the fact that there may be other information that comes to light in the course of a protest. And so a recent example of that was a program, I think it was the Department of Energy. I just saw on the news the other day where unsuccessful offerors filed a protest at the Court of Federal Claims, and they amended their complaint, alleging what I think was OCI issues, and the government ended up taking corrective actions. It's kind of hard to tell what's going on when you've got protective orders in play, but so you don't know the exact nature of the issue, but it seems like that was what was going on there. And so in that instance, the government's got to come back and say, all right, well, now we've got to look at this OCI, right? And is this going to impact the award decision? And ultimately, as many of these issues are, they're just hardly, they're contested in litigation because, with the consolidation of the budgets and shrinking of federal resources and programs are being moved for efficiency, it has been the bane of many contractors seeing a bunch of contracts gobbled up under one roof, because it naturally makes it, for some contractors, a little bit more difficult to compete, because you've got a lot more, whether it's more FTEs that you've got to manage, or you've got more, you may be an IT company that only does a sliver of the work, and now you've got 8 or 9 more task areas to look at, and you're like, well, wait a second, how do we do that? So it comes out, and I think we won't see the end of it. For now, this is just a proposed rule. So FAR subpart 9.5 and the GAO and the court decisions that sort of talk about what an OCI is now are still what contractors should be looking at. If and when this rule becomes finalized, then we'll have a new regime to look at, right?
Yeah. So I believe there are 3 types of OCIs. Can you walk us through that?
Yeah, so those are, your bias ground rules, which is basically you've somehow in some way influenced the requirements development or evaluation criteria for a procurement, right? The ground rules are tipped in your favor. The unequal access to information, which also comes out a lot, which is a really fact-specific OCI. That one it can be very interesting to read when you're reading the GAO decisions, because it really hinges on the facts, and that's just where an entity or an affiliate has an unfair competitive advantage because they have information that was given to them. Maybe you have inadvertently given information from somebody else's proposal, or information that wasn't available to all offerors. And then the third one is the impaired objectivity, which was what I was just discussing, which is, you've got your interests aren't really aligned. The government's looking for an open relationship with a contractor, but in the background, the contractor is not worried about serving its client, the government here. It's also worried about its relationship with this other government client over here, and it may be in a situation where, because it's working on 2 programs and one may be reviewing or overseeing the other, whether or not the government's truly going to get, unimpaired advice, right? Because the contractor's looking out for itself in that situation, or at least that's what they.
It's that last principle that I think what caused the schism years ago with SAIC, spinning out Leidos, having the system integrators in the same room as the CETA advisors. And so, there were several companies like that where there were lots of split offs like that. So, no one would ever come out and say the DoD made us do this or the government did us. That's essentially what happened. They found themselves having a lot of trouble proposing a number of different opportunities. So they're like, what are you talking about? Right down in your hallway, there's people who built this thing, and you're the one who wants to advise whether or not that's safe or that complies with whatever regulation. So that's very interesting. So you were just talking about, so reading. We're going to talk about protest issues a little bit later, but I just want to talk a little bit more about reading GAO decisions. It's not just for lawyers. It's not just for compliance nerds like me. I mean, if you're a business developer, reading those decisions can give you really interesting insights about how certain companies are chasing opportunities in some of the process. And, obviously you're not going to have access to the proprietary information that,
Hmm.
leads to the decision, but there are lots of interesting nuggets in there about, how source selection evaluation boards, rate proposals
Hmm.
and comparing things to each other. So I don't know. I just want to throw that out there and get your thoughts on the importance of reading GAO decisions.
I think you hit the nail on the head. I write often a lot about GAO and court decisions, and knowing what a decision says on the one hand is helpful, but I like to talk about and discuss these decisions through the lens of what happened before the GAO got to its decision, right? And are there any learning lessons that contractors can use down the road? So an example might be task orders, right? So for the last couple of years, GAO's task order jurisdiction was 25 million for DoD procurements, right? Which meant if the value of the order was below that, you can't protest it. In the latest NDAA, that shot up to 35 million, right? And so when I'm working with companies, I say, look, when you're bidding on an effort and it's a task order, and your pricing team comes back and says, hey, we're good to go at $36.5 million, a light bulb should go off, because it may indicate, not always, that the government is looking to award a task order to avoid a protest. And so if all things are being equal and they've got very good responses from company A at 36.5 million and company B at 34.8 million, if the government wants to avoid a task order, they're going to go over here, right? And so that's something to be mindful of. And the other thing that folks need to be mindful of is some of the other stuff that comes out in fixed price contracting, for example. You ordinarily there's always a focus on price. The next company coming in is underbidding, and can they really do the work? And so really having an understanding of what the terms of the solicitation say and how they're going to evaluate price may give you an opportunity to push for questions or seek clarification into exactly how the government's going to evaluate price. Because if you're the incumbent, for example, you know what the price is, and if you're worried that someone's going to undercut you, you may want to try to push for that. Whether the government amends the solicitation is another story, right? But at least you're starting to play with the, because we've got a rule system for government contracting, and contractors need to understand how to use these rules to their advantage, right? And so if you really want to, step up your game, so to speak, it's to pay attention to the GAO decisions to see not just what they're saying, but like, what can we do to avoid these issues, right? And they come out in many, many different ways. I mean, that's just GAO. There's other SBA cases and OHA cases about size and status protests. They're starting to creep up more regularly because folks are seeing a very competitive and contested market for these contracts, because historically the pool of government contractors is going down, but the value of the contracts is also going up, right? And so if you're going to be competing for more work, a lot of the contractors are saying, well, I'm already pot committed if I've spent X number on B and P in the front end. And so if this is a very important strategic award because it's an agency I want to get in, or a customer that I know well, or the value is just so high, they're starting to make more business decisions like, okay, I'm going to protest. And it's not a reaction. It's built into the strategy from when they even submitted their bid, right? Because they know the importance of, because a lot of contractors now looking 3 to 5 years out. Where do I want to be in 5 years, and how do I get there? Now, it's not to say that they're protesting everything, right? Because that's not really a wise strategy. But knowing how to use the rules and knowing when to protest and knowing when to do this, if you can get a contractor, OCI'd out of a procurement, I mean, that's a powerful thing, right? Does it happen
Huge.
all the time? Who knows? But that's
Yeah.
what's going on, and that's why contractors, particularly protesters, are making those arguments.
Yeah. So what you're sort of alluding to is a concept that business developers talk about as ghosting. And, usually it's a way of shaping the RFP such that you're building a requirement that that your competitors are very weak in or just won't have any interest in chasing. Well, OCI, there's another technique for you to
Yeah.
say, asking a strategic question that says, does the government intend for those who are currently working in this department, the office of blah 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 blah, doing this to be a provider of services under this contract?
Mm-hmm.
So using Q&A is a really
Mm-hmm.
important tool during that draft RFP process to, not only shape the RFP, but perhaps get one of your competitors off the bidders list, so to speak.
Yeah. I think this is a good tangent here because
Let's keep going.
there was an interesting protest decision not that long ago about how Q&As factor into the agency's evaluation. And so we all kind of see the Q&A process. I mean, some of these government Q&As are just, there's a lot. I mean, there's a lot of information to digest. But there was a protest that there was a widget for it was a portable satellite type of procurement, and the protester alleged that the awardee's satellite, and I think there was a substantial price delta between the two, and so I'm sure that's why the government went with who they chose. But as it relates to the Q&A, the portable satellite had to be certified, basically, right?
Mm-hmm.
And the protester alleged that the device or whatever that the awardee proposed actually needed to be modified to meet another solicitation requirement. And so because it may have submitted or proposed a portable satellite terminal, whatever it was, that was certified, the agency guidance on the certification process said any deviation from that, you need a recertification. And one of the Q&As was, does the widget need to be certified at the time? And so it became a question of like, does the Q&A govern when you needed to be certified? And GAO agreed with the protester. They said, hey, look, the Q&A unambiguously said you've got to be certified at the proposal submission. And oh, by the way, even though they proposed this widget that was certified, it needed to be modified in order to meet this other solicitation requirement, which meant it needed to go through the recertification process again. So GAO agreed with the protester there. But the powerful thing about that protest is GAO really drilled down into the fact that the Q&As, the questions and the answers, are very much a part of the solicitation. And it can be confusing for folks because there's not always an amendment with a fresh, clean sheet of here's the latest RFP conformed to every single Q&A, right? You sometimes get that, but oftentimes no. And so contractors need to be mindful that those Q&As actually do have a significant bearing in that case, on how the government is going to evaluate your bid. And so,
100%, yeah. When I'm advising my clients working on competitive solicitations, not only should your checklist address your technical checklist and making sure you're meeting all the RFP requirements, checking off that you're meeting all the various SOW requirements, the section L, all the volumes that you're supposed to submit within your response, from technical to security to past performance to price. Make sure that checklist also says, hey, go through those Q&As and make sure that the proposal is addressing all the requirements that's outlined in Q&As. So man, I thank you for bringing to light that protest. I really, really key that Q&As are part of the solicitation as much as the RFP itself, the cover page. I mean, everything that's within, typically within the getsam.gov solicitation is essentially fair game for the government to assess your proposals. Yes. Anyway, so since we're on this topic, let's delve deeper more into the protest side of things, and we can come back later to the cyber if you don't mind.
Sure.
So what are you seeing in the protest world? That's a hot topic right now. For me, key personnel, but maybe you've got some other ideas that I think our listeners would want to hear about.
The lines of communication are clear and open, right? I think what is it, CAVU for aircraft fighter pilots, right?
Okay.
So yes, key personnel is a huge thing. I'm glad you brought it up. Again, this was not scripted here. We're just going off the cuff. But an interesting development, in my view, is we always see key personnel. I mean, I think contractors have a universal, it depends on whether they've gotten bit by this issue before. Because on the one hand, if you're on the other side of it, you're liking it because you're like, yes, key personnel unavailable, you can't have this contract. But if you're on the other side, you're like, are we really letting a procurement system rest on whether John Q. Smith or Jane Q. Smith takes a job, 14 months after proposals were submitted because they've got a family to feed and maybe, and so that's going to upend a $434 million contract. I don't know if there is that fact pattern. I'm making that up, obviously, but that's what happens. You get this situation where someone's no longer. And so not only do you have a divide between the Court of Federal Claims and the GAO on whether or not there's a duty to notify, but the interesting thing about this protest issue is that in the last 18 months or so, I've seen, and I wrote about this, which is why I'm excited to talk about it in Law 360. I've seen 3 cases in GAO where the unavailability of key personnel was surfaced as a defense to the protest. And what I mean by that is either the agency or the defendant intervener, the company that won the contract, said, GAO, you should dismiss this protest because the protesters' key personnel was unavailable. And because the protesters' key personnel was unavailable, they're not an interested party because they can't win the protest. So you're not getting to the substance of I disagree with the technical evaluation. I disagree with the trade-off analysis. I disagree with the pricing evaluation. You're not even getting to the merits of the protest. You're getting dismissed or the protest denied because you're not an interested party, because no matter how true any of these allegations are, you're unawardable and so that is a very interesting development. And so folks that are seeing these procurements with key personnel requirements are going to have to start thinking like, okay, if I'm the protester, I also now need to be alert that someone might say, and it usually goes something like this, they're putting stuff on they clearly don't have this person hired. Obviously they're hiring for that exact position on their careers page of their website. Or you get into the record and you realize they proposed a person and you're like, well, wait a second, that person just changed jobs like 3 months ago, according to their LinkedIn profile. And, so their most recent case was publicly available information suggested that the person left and was unavailable, right? And in my mind, that's usually LinkedIn, right? It's your clear indicator that person. So these are contested. Sometimes key personnel are, another way they get, into interesting snafus is where more than one company want to propose the same key person because it's a very, sometimes it's a very, and there was, so these are hot button issues that, again, I think frustrate many contractors. At GAO, if you have actual knowledge that the key person has left, if you don't have knowledge, there's no duty to notify. Mm-hmm. So if the person takes a job and they just had a letter of commitment and your response is, well, I didn't know they left and they signed a letter of commitment and they didn't renege it. So how do I know they're actually unavailable? But when they become unavailable, you're supposed to notify the government. And the problem there is the government can do 2 things according to GAO's view, right? They can either open discussions to enable you to substitute the key person, which would mean that they have to open discussions with all offerors that are basically in the competitive range, right? Because a discussion is you're changing your proposal, not merely a clarification. Or they can evaluate your bid as is which essentially means you're unawardable because your key person's not there. At the court, on the other hand, in the case that, I don't want to say the seminal case, but one of the cases that really basically announced, hey, we're not going with GAO, was actually sadly a case that I lost. But that was a very interesting, matter, because the court basically said, I don't know where GAO is getting this rule from. I can't figure it out. I don't know where it is. Why is there a duty to notify if the key person? And basically said, I'm not going to follow that. And since then, a couple other courts, and none of the judges at the Court of Federal Claims are binding, right? They often align, but they don't have to. They only really need to, they're only bound to predecessor Court of Claims decisions in the Federal Circuit and the Supreme Court, right? But Judge A and Judge B don't act, they can arrive at different, conclusions on the same issue based on their reading of the law or the statute or whatever. And so, there's a collection of judges right now that have basically said, we don't see where GAO is getting their reasoning on this. And so now you have another interesting development in cases where GAO rules one way, and if it's not a task order where you can't go to the court, you're going over here to say, and this was another case that happened last year, I think, where they said the agency's evaluation was unreasonable because it relied on GAO's decision, which itself was unreasonable or arbitrary and capricious, because the court said under the fact pattern, the person wasn't actually unavailable. So they shouldn't have been knocked out because the person was still available. So now it's going to be it'll be interesting to see if GAO changes its view on key personnel in light of a lot of folks seeming to have issues with it. And it will also be interesting to see if a judge on the Court of Federal Claims agrees with GAO and takes a different position than the others, which would then invite potentially a contractor to inevitably take this matter to the Court of Appeals for the Federal Circuit to have, the Fed Circ, give its 2 cents on this, and maybe, just maybe, provide enough clarity so that contractors don't get sidelined by someone deciding to take another job and it upending a bid. So it's a difficult situation for a lot of folks.
Yeah, I mean, it's created a cottage industry of people that just troll LinkedIn profiles for where these, project manager type people are going day-to-day basis, or SMEs.
Mm-hmm.
I don't know if that was really the intention, it's interesting. So, all right, I'll put you on the spot. You're the chief procurement executive at NASA or one of these big agencies, or you're on when that person happens to be on the FAR council. Is there a rule you think that do you think regulation can fix this, or is this something that needs to get attached to an NDA in the future? Is there a way to fix this problem?
Well, the key personnel rule at GAO is out of case law.
Okay.
There isn't. I mean, this issue at GAO goes back quite some time.
Yeah,
and I think the cases have kind of morphed, as the years progressed. But now we've got sort of this basic rule that says if you have actual knowledge of the unavailability of a key person, you've got to notify. So, actual knowledge is heavily litigated at GAO, and then are they actually unavailable? Like, what does it mean to be unavailable? And so I think, what I have seen from GAO they have sometimes borrowed language from the Federal Circuit. One area is disparate treatment. So there's a case in 2020, I think it was, about disparate treatment, and that is sort of another mainstay of protest arguments, which is, hey, you evaluated Jeff's bid like this, and I bid basically the same thing. And why did Jeff get a strength and I get a weakness, right? And so, but the cases at the court, or let me rephrase that, the case on that issue at the Court of Appeals for the Federal Circuit basically say, you have to have substantively indistinguishable or nearly identical bids. And so that has now creeping into GAO cases as their standard, because it was slightly different before. But there was a case, I'm glad you brought this up. There was a case actually last week, I think, that was on unequal treatment, and it used that same, I don't know, I haven't read it yet, but
It
I
wasn't key personnel. It was something else. But
no,
keep going.
it was disparate treatment, and I think it was a sustained. I don't know if they cited that case, but the interesting thing there is, and I should probably go back and read it, is I have seen disparate treatment cases at GAO cite this substantively indistinguishable standard, and I've seen other cases since that rule was announced by the Federal Circuit rely on its own collection of cases. So it'll be interesting to see if GAO harmonizes and moves forward with that. But that was an interesting case because I believe the protester won on that issue on disparate treatment, and I think it was about I read so many cases that was one that I saw on LinkedIn, and I was like, oh, remind yourself to read it actually in earnest and think of it. It was a situation where I think it was like you proposed a bench, right? We've got a deep bench. And they're like, well, you gave them a strength for this deep bench. And they're like, well, you proposed a warm bench. And GAO was like, it's the same thing. You got a bench of people that you're going to call upon if you need a surge requirement or whatever the issue was, right?
Yes.
So, but at the Court of Federal Claims, at least in my experience, substantively indistinguishable or nearly identical, can be a source of frustration for protesters, because is the standard identical or nearly identical? Is it exactly the same, or is it basically the same? And I've seen cases where it's kind of seems like they proposed the same thing, but the way that they're being evaluated is sort of more on the lines of you're not going to have the same sentence in your proposal. I mean, unless you use this, copied each other. So what is it going to look like? So where is the true line of substantively indistinguishable? And again, shame on me for not synthesizing that case before this call. I should probably read that and see what GAO said, because that was an issue where they said, hey, pretty much the same thing. So why did you, and that goes back to the hallmark of government contracting, which is you got to treat people fairly, right? We got to, if it's got to be an apples to apples evaluation here, right? If you're going to give contractor A a strength for this, and you've got to give a contractor B a strength for that, right?
Absolutely.
So,
all right. So Josh, let me ask you the general tough question that you probably get 3 times a week. When should I protest?
I think there are a couple things to consider for protesting. One is value of contract. What was your business development and capture effort like? Did you have a strong sense that you could win this, right? Or was it a one-off, hey, we learned about this late, but it's really in our wheelhouse. We don't typically go after bids like this, but let's just, throw out the Hail Mary like Jaden Daniels did in that epic game earlier this season, and resulted in a nice touchdown and a win. Yes. So sometimes that happens, but a lot of the times it's the value of the procurement, the specific customer, if you're trying to get in with another agency, or you're trying to establish more of a rooted, more roots within an agency. And then going back to what we talked about earlier in the episode here, what are the protest issues I'm going to be looking at? Because it can't be, I don't like that I lost, because that's just a subjective, the standard at GAO is reasonable, which ostensibly is an arbitrary and capricious type of standard, which is what governs protests at the Court of Federal Claims, right? And so if the government can articulate its reasons, then you're most likely going to be out of luck, unless those reasons evince a procedural error, which can be, we got a weakness, and everything that they're talking about is something that is not mentioned anywhere in the solicitation. In fact, not only is it not mentioned in the solicitation, it doesn't even have a nexus to any of the other evaluation factors. So why are we being evaluated on this? Is an unstated, had I known that this was what they were truly looking for, I would have written my proposal completely differently, right? So that's an objective. And so the problem with protesters is you don't know until you get the record. All you have at best is a debriefing that gives you some information as to the evaluation and maybe a redacted source selection document. But if you want to go protest, it needs to be with an understanding that, chances are you're really going to need to be, the protest doesn't really start, at least unfortunately, at GAO until the record is produced. Because you're going against a stacked deck because you just don't have information. You just have your information and public available information. And GAO's pleading standard, if you will, is arguably a more stringent pleading standard than it is to get into a federal courthouse.
Wow.
Because they don't allow speculative protests, even if those speculative protests could potentially be true, right? I've seen protests get knocked out where they say, well, as much as you might be right, this other thing might be right. So that means it's speculative. In federal court, if you've got enough facts and plausibility, it survives typically the, Twombly, Iqbal, what's in these cases that come out of the Supreme Court that say what's needed to plead a complaint in federal court. And so when you don't have the information, that's when you see, like, upon information and belief, we think this happened, right? At GAO, it's a little bit, basically it's a little bit higher of a standard because you have to know what went wrong. And that only way you really know that is at the beginning, at the onset of a protest, is my debriefing, what I know publicly, what I can extrapolate from the awardee's website or public information, or when, one of the things that was all the rage is, did you have a lapse in your SAM registration, which I believe there's an interim rule on that. So that's really not so much of an issue as it used to be years ago. But that was one thing that protest attorneys looked for. Is their SAM profile current? If not, I'm going to say they're ineligible, right? And so, but when you get the record at GAO, then you have an opportunity to see what transpired, and then you can either withdraw because the record is not going to bear out your arguments in a way that will show prejudice, even if there were flaws, or B, you say, now we know there's some mistakes here, right? Because now we can see, at least when you're, you at GAO, you pretty much, you can do a pro se protest, but you really need your outside counsel because you want to be able to see an unredacted source selection document, right? And you can say, this is wrong. They, made their evaluation rested on unstated evaluation criteria. They gave the awardee a strength for proposing a warm bench of surge support, and we didn't even get that over here, and we proposed a warm bench of surge support, so what gives? And, oh, by the way, here's some regulatory things they were supposed to do, and they didn't do those right either, right? That's all for post-award protests, right? And so when you get to the record, you can either withdraw or you can continue to fight on, right? So when contractors are asking whether or not I should protest, is this a close call? Are you kind of, does it look like you could be an awardee, or did you get so many weaknesses that it looks like you're not even in the running? But I have to use caution there because, I had a protest. I've had more than one protest where that was the case, and it was because the government evaluated the offeror in a completely different. I mean, it was just RFP said we're going to evaluate you on this, and they just did banana, right? I mean, so yeah, you gave us all these weaknesses, but you're evaluating us on a standard that did not exist in the solicitation. It was a lot of the times it's, tell us how tell us about your past experience doing X, and then you've got task areas and subtask areas, and then the evaluation comes out and it's something like, you didn't tell us the exact process you would use to satisfy C.3.2.1. And you're like, well, wait a second. You didn't ask that. You just said, tell us your experience and how you would, with all these, discrete cybersecurity and IT information systems stuff, right? Not how we would solve your problem, which we don't know because we only have an RFP in front of us, right? So it can be difficult. At the court, slightly different. You don't get there's the task order issue for jurisdiction purposes, and there's also, there's no statutory seek a stay. So if you go to the GAO, you can trigger a seek a stay, which stops performance. At GAO, it's either negotiated or you have to fight a PI, preliminary injunction, right? So it's a lot different. I think companies are walking into protest more with eyes wide open and understanding the process, and they're willing to pull back and withdraw after they get the record. Because if it doesn't look like the protest is gonna bear out the way you want to, because the record shows the agency's actions were supportable by reason and documentation, and you back out and you live to fight another day, right? But that's and there's other. I mean, obviously we didn't talk about agency level protests, but folks should be mindful of that, right? You're looking for if you're reading your debriefing or a sample why they gave you a weakness, and that doesn't really comport with what the solicitation said, how you would be evaluated, then maybe that's a light bulb. Well, wait a second. We got all these weaknesses for this stuff, but that's not really mentioned in the solicitation. So that's just an unstated evaluation criteria. Whether or not that is borne out in a real record, I don't say real record, but like the contemporaneous record, not just whatever they've given you in response to the debrief, is a different story. But there's a host of other protest arguments about price and past performance, and what you can do to kind of show that there may have been a flaw. But it's the record, GAO cases, they see a lot of protests, so it's a good place to go. The record can be sometimes an impediment, but and that's because the agency is only required to produce under GAO's rules the relevant the relevant record, right? What's relevant to the protest arguments. At the court, on the other hand, you're getting the full enchilada, as they say. They're required by the rules to give everything, right?
Yep.
So it's a interesting. I like it. I'm a bid protest attorney. I'm also not one to just. There's got to be there's business reasons for protesting too. There's a lot of strategy involved. When you talk about should business developers or folks that are not the lawyers, but should they be paying attention to the protest system? Read the facts, right? It's the cases and how they distill a legal issue is incredible. That gives you a lot of information.
Tons, yeah.
But sometimes, when you see a protest, protests are docketed with this B number, B da 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 da, right? And every time there's a supplemental protest or a filing, it gets a dot next to it. So as we can all remember, when CIO SB4 was heavily litigated, it was like B blah 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 dot 358, because there were over 300 protests that related to that procurement, right?
Yep.
But if you're reading a decision and it's like B blah, and then they list them all and it's like up to dot 11, that tells you that there has been a lot of protest activity related to that one procurement. And so you want to read the facts, because sometimes it's the government taking corrective action and then they're coming back, and then the protesters challenging the corrective action itself. And what can you glean from that information? Because at all these points in time, there's something that you can tuck away in your procurement toolbox to make sure that you're prepared, not just for a protest, but just be prepared for a procurement, right? And so when you read the facts and think about how the course of a procurement has transpired, it's, sometimes they deal with pre-award challenges, and then the agency's response and the pre-award protest and the Q&As, and then all through the corrective action and second rounds of corrective action, and the government's doing things, and so those are things to be mindful of, because I think they're a way to sharpen the knives, so to speak, so that you're ready for, the procurement itself. Because if you don't know the thing about the Q&As, if you don't know where a company has been safe and GAO said, no, you're good, there was no duty to notify, they either didn't have knowledge, because if you know what that line is of where the knowledge is or where they were actually unavailable, then you know going in what will trip you up and what won't, right? And so you can guard against that by the way that you interact and write your letters of commitment or whatever have you, right? And then when something does come up, because we thought about that before, they're fine, and so it's a lot. I think I could go on and for days on protests, but I'll leave it at that.
There's lots to cover here, and we can do a whole separate episode. We didn't even touch on the
No, we didn't. I mean, those are.
But to your point with the post-award issues that you just relayed, and understanding and reading these GAO documents, like we suggested before, you have to remember that these solicitations and how proposals are evaluated, they're still done by people, and these people and in these agencies, although I guess these days maybe a little bit more than before, but generally they don't change the policies and procedures and how they're trained on how to do the evaluation. It's typically done by the same people. You usually pick up these folks, you put them in an outbuilding that hasn't been used in 25 years. Say, all right, for the next 2 weeks, we're going to be sitting down and evaluating proposals. We're going to make sure we do one at a time, and they do all the training. But and then, how fast agencies learn from their mistakes, we'll call them that. It takes a little bit of time. So understanding their playbook, this is a great source for that, and understanding, what to expect for that next proposal that goes into that same office or that same even agency. I mean, it's that wide, I'd say. There's going to be similar approaches taken, and there's a lot of lessons that can be learned by interested bidders.
Yeah, I think so. I mean, when you're thinking of bidding, you got the Q&A issue, and you've got, a host. I mean, once the bids are due, you're stuck with whatever the RFP says. So if you think that there's something that is ambiguous or could be considered then the time is then, because only the GAO after the fact is going to say, if it was patently ambiguous, then you should have done. Now there's wiggle room if something's latently ambiguous and it's not really apparent on the face that that's what would happen, but you can't rest your bid on that. So if you think that the evaluation is running afoul of how SBA says something needs to be evaluated because there's a lot of rules under Title 13, or how Section M outlines the technical evaluation, I mean, you got to get those either Q&As in, or you got to be willing to file the pre-award protest, because you want the agency to commit. And you could have an entire podcast, so we won't get to that today because we don't have that much time, but you could have I've been talking to someone else, one of our friends, about this opportunity to maybe have a podcast only on Q&As, because there is an art to the Q&A process, because sometimes you want the answer and sometimes you don't want the answer. But you have to be mindful, because if you don't ask the question and they evaluate you in the way that you didn't want, then you've hurt yourself. You're in an unfortunate position of being stuck, because the cases basically say you can't roll the dice and hope that it goes your way, and then protest after the fact that the solicitation was clearly ambiguous and didn't really say what it said, right? Is that
great? They're
just going to say that you're wasting time in the procurement process. You should have done that 5 months ago, right?
Yeah. Even when the Q&A process is technically closed, but the final proposal isn't due yet, and you still think there's something ambiguous, keep asking a question. If it wasn't asked, especially, be like, ooh, you still see something, you got to try asking, because otherwise you'll have no standing when you say, but I asked the question and then you evaluated me against this criteria that I specifically asked, what did you mean by
Yep.
blank? Because I could interpret it to mean this, or this. If they don't come back and answer that, and all of a sudden your proposal's due, then you got that tough decision to make whether not to submit protest.
Exactly. They had to be the portable terminal for satellites had to be certified at the time of proposal submission. Well,
Yeah.
what is that really? Is that really a solicitation requirement? Well, in that case, it became a solicitation requirement because GAO clarified what the solicitation meant, right? So it's important stuff. Obviously, it, adds to the reading list, as they say, but the contractors that are paying attention are able to take these learning lessons from each protest, and make different decisions down the road for how they're going to operate in the context of bidding and submitting proposals, right? So one thing that always comes up is the late proposal rule, right? And there's another split there with GAO and the court on emailed proposals, and a lot of times, with DoD at least, they have these fancy things called email gateways and firewalls and malware servers that scan your stuff before they make it to the inbox of the intended recipient, whether it's the core or the CO. So, and some of those systems don't give you a bounce back email. And so at GAO, your proposal is timely when it gets to the designated person, not the government, unless you've done it in a sufficient time to say that it's under the government's control because you submitted it a day before. But GAO's reading of that proposal submission rule is different than a couple cases at the court.
Wow.
There's a little bit more. I mean, if you're dealing with that issue, assuming there isn't a task order issue where you can't go to the court, I mean, you may have a more favorable time. Going to the GAO, I mean, they're pretty strict. If the KO or the core doesn't get that email in their inbox prior to the deadline,
you're out of luck.
You're probably going to be out of luck. And so contractors need to, I tell people all the time, submit it by noon we're one working day before.
Seriously.
Yeah,
then, long gone are the days where you're driving up with your truck with the pallet proposal volumes and copies of the CD. You're rolling up and saying, knock, knock. Hi, contracting officer. Here you go.
Oh, yeah.
Here's a time. Now let me sign that I received it on this day at this time.
I know.
Long gone. That's some people, I'm sure, still wishing for those days.
Yeah. I mean, yeah, that's, you get stopped by base security. You can't get into the building. It doesn't make it to the right part of the building on time.
Yeah, we had those. That was definitely a 1990s type case, I'm sure. I am sure of that.
I mean, there's, we only received 2 of your 3 CDs, so therefore you're out of luck. You're like, dang it, I know I gave you 3 CDs of material, but how do you? So it's, the government contracting landscape, at least for, I think, folks like you and me who are nerd out on it, I guess, has changed a lot in 20 years.
Absolutely.
And it's going to continue to change. I mean, when we talk about changes in the government contracting landscape, I mean, kudos to us because we didn't talk about any of all of the other changes that are happening at this very moment with various executive actions and agency things that are happening to sort of promote efficiency or whatever, but it's impacting contractors because they have rights on that side. So that's all I'll say about that because there's a lot of things that we could have talked about in that respect.
But speaking of RP criteria, Josh, I can't let you go.
Yeah,
but we're not talking some cyber. I'm sorry. We got to spend a couple of minutes talking about cyber and what you're seeing with the latest in regulations. We got the CMMC rule, finally a final rule. We've got a FAR rule that's in process to create a whole new section of the FAR. I mean, how often do you see that? I don't think in my career had I seen, at least not off the top of my head, that I've seen a whole part be created. So love to hear, what you're seeing as the latest on CMMC and what folks should be aware of.
Yeah, I think, as many of the audience probably is aware, there's this new thing called the CMMC, and that is the Cybersecurity Maturity Model Certification. And that is Department of Defense, right? And that was in response to a requirement that's been in the FAR this DFARS 252.204-7012, which required contractors to provide adequate security on contractor information systems where they process, store, transmit CUI, covered defense information, basically. Companies weren't doing that. They were taking liberties with the fact that you could have a POAM and you could get to it later. DoD didn't like that. Google DoD contractor cybersecurity incident, and they're countless. And so many years ago, they said, we're going to make a different system. We're going to make contractors get third-party certifications. And so now we are entrenched in that process. We have a CMMC rule, and now we are waiting for to have a companion FAR rule finalized. So the CMMC rule is out there. It's been finalized. It talks about the 3 levels of certification. Well, let me rephrase that. There's a self-attestation for level 1. There's a self-certification or a third-party certification for level 2, and there's a third-party certification for level 3, right? So that's the new regime. Most of the contractors in the DoD, they're probably going to be needing CMMC level 2 certified. Even if it seems like you may be able to get away with a CMMC level 2 self-assessment, it's probably not, it's probably not going to be, there are going to be too many companies that are doing that. And so what ended up happening most recently is there was a DoD memo that was published not so long ago in January, just before the president took office, about, how do you know what your compliance level is going to be? And the interesting thing here is if you've got federal contract information only, then you're in CMMC level 1, which basically parrots the FAR safeguarding rule, 52204-21. Level 2 is, again, the one area where you can either have a self or a third party. And basically, if your contract has controlled and classified information that fits any one of the defense grouping in NARA, which is the National Archives and Records Administration. So they've grouped CUI. There's like 20 categories.
Yep.
Well, DoD is through this memo has said, look, if your contract involves controlled technical information, DoD critical infrastructure security information, nuclear propulsion stuff, the Navy's got these things called nuclear submarines, right?
I've heard of those, yes.
Or safety information or unclassified controlled nuclear information. If you've got that type of CUI, you're going to have a level 2 certification. And then the memo says that if it doesn't involve that, if it's just regular, I hate to say regular CUI, but if it falls within any of the other categories of CUI, then the contractor will need a CMMC level 2 assessment. So I think they're trying to find a way to make it so that fewer contractors have to have a third-party certification, which is ironic because the entire purpose, in fact, the driving force behind the CMMC has been contractors aren't actually implementing this requirement. And so we need to make a third-party regime so that they can actually, we have knowledge that they're actually doing this stuff. So that's all to say that we're still early in the process. I don't think contractors should be waiting. But once the FAR rule comes into play, then it's going to trigger when the actual CMMC requirements are going to start showing up in procurements. But, we have gone a long way and there's a ways to go. But if you're doing business with the DoD, this ain't going away. And oh, by the way, there's going to be federal civilian agencies are going to, this FAR rule also talks about implementing for civilian efforts, NIST 800-171 revision 2, which mirrors the requirements under CMMC level 2, which is to follow the 110 security requirements under that document, which is sort of doesn't tell the whole picture because any of these cybersecurity consultants will tell you there's an assessing objective document that they use, and that has 320 assessing objectives in order to show that you've actually met a requirement. So there's a lot of work to be done, and this isn't going away. And I've been saying this for 6 or 7 years now. It is going to bleed into the commercial sector, because if I'm an insurance company, I'm going to say, aha, get CMMC level 2 and your premiums will go down, right? If you don't have CMMC level 2, then your premiums will be a little bit higher. But because I know that your information systems have at least been looked at by a third party, I have a little bit more confidence that maybe, not that you won't get breached, but the severity of the breach won't be as bad as someone who just has had their head in the sand like an ostrich and hasn't been paying attention. And now I've got all this fallout, right? So I could be wrong, but I think that's where we're headed. I mean,
yeah, that's a very interesting prediction. I mean, what you're telling me here is cybersecurity verification by third parties is almost going to be akin to your financial statements being audited by a third-party CPA firm. I mean, there are stakeholders all over the place. You know, one case being your investors, the other case being insurance companies, and I would probably argue the investors as well. Well, I like that prediction where that's going.
It's still, I don't want to say chaotic, because there's so many different cybersecurity regimes in government.
Yeah.
And it's starting to, I mean, you know, SolarWinds had that snafu, right? And that made its way into SEC litigation, where the company was basically saying, look, we told you in our financial statements that there could be a potential, you know, and that has, you know, and part of the issue with the defendants were bringing up was these aren't financial issues related to public company, you know, so why are we even, and so that, you know, for publicly traded companies, you have to be mindful, because there are not only the DoD stuff for if you're a defense contractor, but if you're publicly traded, then you've got all these other requirements. And when you're filing your you know, 10K or whatever, your quarterly, annual or quarterly updates to say, hey, we have, you know, we may have a security incident, but we've hired outside counsel and they're investigating it. We don't think that there's going to be a material impact on stock price, but we've engaged all the appropriate outside, you know, XYZ. I mean, but it becomes a problem of, you know, especially when it comes to breach response notifications, right? One regime says 72 hours. Another one says 8 hours. Another one says reasonable time. Another one says within 24 hours. And so now you're juggling competing time frames when you have reasonable belief that you need to make a notification. And it becomes kind of a headache, because it's a jigsaw puzzle that's being, you know, it's like the you know, you're jumping off of a mountain, and then you're building the plane in flight and hoping that you can finish building the plane before you hit the bottom, right? I mean, that's what's kind of happening, is we're building the plane mid-flight and hoping that we can find a solution to this. But this is a complex problem. I mean, nobody is going to be immune from a data breach. That's a cottage industry. I mean, people make their livelihoods through independent third-party actors or nation-state sponsors or whatever to do this stuff, because they have a computer that connects to the internet and they're smart and they know that this type of organization with this type of information most likely will pay the ransom, because they need to get their health records back, right? And so they know, and
how missiles are built, or
I mean, the FBI knows who pays. And so, it's a transaction to them being the bad actors, the threat actors.
Yep.
And they want folks to know that they will give you the decryption code, because it's a business transaction for them. Because if they stop giving you the decryption code, people are going to stop paying the ransom. So they very much approach it like a business. It's unfortunate that that's what's happening. But, you know, when you circle it back to DoD, that's what they were worried about, which is no one was really taking this cybersecurity stuff seriously. So let's put a third-party regime on top of it and make contractors get some sort of certificate or whatever that says that they've implemented a reasonable measure, and now it's the whole thing. You've got to have all of them. And there's some language to potentially have some flexibility. But basically, you've got to implement these in order to be eligible to win a contract. And so as contractors move forward, it's going to be imperative that they are doing this now and be prepared that you may be more in line with CMMC level 2 certified, not CMMC level 2 self-attestation, right? So your first contract may say self, but if you're going to be in the supply chain, eventually you're going to have a third party do it. So it's worth the time and energy and expense to start building your system now, so that when large primes want to have you as a subcontractor, they may say, you got to be certified.
Yeah, and certification is not an overnight process. You can't just walk into a company who's a C3PAO, that my firm happens to be, and say, hey, I need this done by next week so I can hand in my proposal.
It doesn't work like that.
Planning that needs to be put in place, and you read that manual and you think that you've got all those NIST standards addressed. The audit, the accreditation process takes some time, so you gotta keep that into consideration. So yeah, I mean, everything we talked about here, Josh, planning, right? Thinking ahead. We started out with OCIs and understanding, how your organization, whether you're potentially hiring a former federal employee, or maybe you're thinking about buying a business that, seems to be a good vertical integration for you, that, hey, make sure you're considering those potential OCI risks when you're doing that. While you might improve your supply chain, you may be restricting yourself some competition down the road. So planning. So, so understanding what OCIs are about and what that rule, where that's leading. And, we didn't talk about it at the time, but this is, when you see rules like this, and it could drastically, impact your business today, tomorrow, the next day, you got to say something. And, whether that's through an industry association or sending it directly, if you don't say anything, don't expect anything to change and just assume, oh, someone else must have that problem. I'm sure they'll say something. Now, there's a reason why, these rules are published for public consumption. And you'll see in these rules, every comment that goes in essentially needs to be acted upon. And the details that come out in the Federal Register says, we got a comment about blah, 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 blah. Well, this is what we considered and why we thought you were full of good junk and we were right. Okay, at least you tried.
Yeah, they read them. I mean, they're required. I mean,
have to.
SBA published a rule that I thought, and we didn't get into it, but there's some changing landscape with SBA rules with respect to M&A. And one of the rules dealt with negative affiliation control. And the way that the proposed rule was written was like, you're going to be boxed into a certain number of unanimity requirements. If you're a minority shareholder, you want to be able to have some certainty that your financial investment isn't impaired by a majority shareholder that can take action, all kinds of actions for the company. And in response to comments, SBA added another one that basically was a catch-all that said, and any other provision that would enable you to protect your investment, which basically reverts that rule back to the established case law at the Office of Hearings and Appeals, the SBA OHA, that says, yeah, if you want to have a unanimity provision where you need to vote, you need to secure the minority shareholders' vote in order to take this action. If it protects their financial investment in the company, they've got to be involved, right? And so that's what they were talking about. And now it gave a little bit of a breathing room for all those people, individual investors and others that want to invest in small businesses, because industry responded to the comments. SBA said, okay, this makes sense. We will revise our proposed rule. And so that's where you have to engage. Absolutely. And that happened with the DoD CMMC rule. They got hundreds and hundreds of comments, and they made refinements along the way. And that's, I think, the way it's supposed to work out.
Absolutely. Absolutely. No, when rulemaking works right, it works. And we have to continually adjust. Other themes we talked about here today, we talked about reading GAO cases. It's not, you think it's meant for lawyers. It's not. It's really, there's lots of folks, if you're in the industry, it's a great source of information to understand your buyers better, understand your competitors better. There's a lot of great information there. And then CMMC. I mean, we've been banging this drum for years, and Katie Arrington first announced it how many years ago, Josh? 6 is definitely the pandemic. And now look who's, at least this, as of today's podcast, the acting CIO of the whole Department of Defense, Katie Arrington. And she has been emphatic that CMMC has to be implemented across the DIB. And, now with the motion, other non-defense agencies seeing that and that rule, it's not going anywhere, folks.
Nope.
It's time to take it seriously if you haven't already, and understanding it doesn't have to cripple your business. That is not the intention of the federal government, like any other compliance requirements there are. And I hear that argument, God knows how many times. But ultimately, it's for the safety and security of not only the federal government, but Josh just made the point. It's value added for your own business. Like you're putting all these rate controls into place so you can safeguard your futures, your shareholders' futures. Really critical things here that we talked about here, Josh. And I know we could talk a lot longer on some of these topics. But any other takeaways you want to make sure the listeners walk away from today?
No, I think that's it. Just be mindful, and this is a turbulent time, I suppose, for government contracting.
Absolutely.
But the business of government still needs to happen, and so there's always going to the landscape may be shifting, but the more you can take advantage of the tools that are out there at your disposal and use those to inform your decision making, I think will pay dividends down the road, because the government contracting marketplace is going to only become more competitive.
Totally agree. I'll give a free plug for Josh. You've alluded to it a couple of times. You have a great blog for lawyers and non-lawyers alike. Yeah, can you let folks know the name of that?
Yep, it's GovCon Judicata, Judicata. And so it's on LinkedIn. You can follow that. There's a website, govconjudicata.com. You can subscribe there, and periodically I send newsletters and updates. But I try to, I don't catch everything. It's just me doing it, but I try to keep folks aware of what's going on in and around the GovCon space, so that they can, make better business decisions on the front end, right?
Yeah, thanks for that, Josh. I love that resource. I'm on it all the time, so I
Appreciate it.
you that. Everyone listening, link in with us. Give us feedback. What did you think of today's podcast? Like it, or hate it, or indifferent? We want to hear it all. We want to know what else we can be bringing you as part of our Optimized podcast series. Josh, thank you so much for joining us today. I had a great time, learned a lot. Look forward to more continuing these kinds of conversations in the future.
Thanks, Jeff. Glad to be here. And thanks, everyone, for listening.
Absolutely. Thanks, all.
And that wraps up this episode of the Optimized podcast. A big shout out to our amazing host, Jeff Shapiro, and our guest, Josh Duvall. You can connect with Josh in the links in the description. Optimize is brought to you by VisibleThread, the RFP software for analyzing solicitations and contracts, and for creating and editing proposals. VisibleThread is used by 11 of the top 15 US government contractors. For more information, visit VisibleThread.com. If you enjoyed today's episode, please subscribe, rate, and review us wherever you are listening. Stay tuned for more insightful discussions on the Optimized podcast.